Welcome to the explainer. Okay, so picture this. Someone's got something that belongs to you. Maybe it's your car, maybe it's some equipment, and they just refuse to give it back. It's frustrating, right? Well, today we're going to break down the legal tool that's built for exactly this kind of situation.
All right, let's kick things off with a super common scenario. A person defaults on their car loan. Now the creditor, they have every right to get that car back. But here's the kicker. The debtor just won't hand over the keys. They're basically holding the car hostage.
So if you're the one who rightfully owns that car, what do? How do you get your property back without getting stuck in a legal battle for years? You need something fast, right? What's the legal equivalent of an emergency key?
And that answer is a special legal action called Replevin. Now, it's what lawyers call a provisional remedy, and it's all laid out in Rule 60 of the Rules of Court. But don't let the fancy words fool you. Its whole job is simple: to get your property back where it belongs and to do it quickly.
Okay, let's zoom in on a couple of keywords here: provisional and ancillary. Provisional just means it's a temporary fix. You get your stuff back now while the bigger court case about who ultimately owns it is still going on. And ancillary? That just means it can't be a standalone thing. It's like a side dish. It has to be part of a main course, which is your main lawsuit.
Now, this is where things can get a little confusing, so let's clear it up. People often mix up Replevin with something called preliminary attachment, but they're totally different. Just think of it like this. Replevin is for getting your property back. Attachment is for holding on to the defendant's property, kind of like collateral, to make sure you get paid if you win a money judgment later. See? One is about your stuff, the other is about their stuff.
Okay, so you're sold on the idea, but how does it actually work? What's the recipe you need to follow to get a court to grant you this powerful tool, this writ of Replevin?
It really boils down to two essential pillars. You can't have one without the other. First, you've got the affidavit of merit. That's your sworn statement. And second, you've got the Replevin bond. That's your financial guarantee. Let's dig into what each one of these really means.
So that affidavit, it's not just a simple form. This is where you have to lay it all on the line, under oath. You got to swear that you're the owner or you have the right to possess it, that the other guy's holding on to it wrongfully. And this is super important. You have to state the property's actual market value. And you'll see why that number is so crucial in just a second.
Which brings us to pillar number 2, the bond. This is the court's way of making sure the defendant is protected. And get this, you have to put up a bond for double the value of the property. Yep, you heard that right. 2 times the value you just swore to in your affidavit.
And this bond isn't just some court fee. Not at all. Think of it as a massive security deposit. It's there in case the court finds out later, hey, you actually weren't entitled to this property after all. If that happens, the bond is used to pay for any damages and to make sure the defendant is made whole. So the takeaway here is pretty clear. You better be absolutely confident in your claim before you go down this road.
All right, so we've covered the rules in the book, but how does this play out in the real world? Let's check out some actual court cases to see how judges have interpreted these rules.
Okay, here's a question that comes up all the time. Do you have to send a demand letter first? Officially ask for it back and wait for them to say no before you can even file for Replevin? Well, the Supreme Court gave a crystal clear answer on this one. In a case called Navarro versus Escobedo, they said, nope, you don't. A prior demand is not a requirement. As long as you've got your affidavit and your bond ready to go, the 2 pillars we talked about from Rule 60, you can go straight to court.
But this leads to the absolute heart of the matter. The whole thing rests on your claim that the property is being wrongfully detained. So, what happens if the other person actually has a legitimate legal reason to have it?
This is where a classic case, Twin Ace versus Rufina, teaches us a huge lesson. So you had this beverage company, Twin Ace, and they sued a fish sauce maker, Rufina, to get their branded bottles back. Twin Ace filed for Replevin, claiming Rufina was wrongfully using their bottles. But Rufina came back with something pretty powerful, a law that specifically allowed the use of these kinds of marked bottles for native products, like fish sauce or patis.
So, what happened? The court denied the writ of Replevin. The takeaway was simple and powerful. Rufina's possession wasn't wrongful because the law made it lawful. You just can't use Replevin to take back property from someone who has a legal right to possess it. It all comes back to that one critical word: wrongful.
All right, let's wrap this up. What are the main things you absolutely need to remember about Replevin?
First, remember it's a fast, temporary remedy for getting back physical, personal property. And I stress personal property. This doesn't work for land or buildings. Second, it's a serious process. You need that super specific affidavit and that big bond for double the property's value. Third, and this is the big one, your whole case lives or dies on proving the other person is wrongfully holding your stuff. And finally, don't forget you don't need to send a demand letter first.
And that leaves us with one last, really important thought. Getting the property back with Replevin is great, but it's just step one. The main case still has to finish. So what happens if the property gets damaged or lost in the meantime? Well, the rules have an answer for that. The final court judgment isn't just a simple you win or you lose. It has to provide an alternative. Either you get the property back, or, if that's not possible anymore, you get its value in cash. It's a built-in safety net that makes sure there's a fair resolution no matter what.